notifiable information is bound under the Notifiable Data Breaches Scheme. So the data they hold, in theory, they have to keep secure. Most of the organisations that I audit don't even know their information flow. So I'd argue that there's a real disconnect there already with how can they uphold their obligations under that law. There's also the Privacy Act, and there's the Telecommunications Act, there's the Telecommunications Deception Act. For the companies that are dealing internationally, so it's still an Australian company, but it might have association with someone in Europe or England. We've got the GDPR, which is very relevant. US companies, so the California Consumer Privacy Act, 2018, you've got in Singapore, Personal Data Protection Act, and amendments. So everywhere that Australia might be dealing, or a listed company might be dealing, there are unique obligations. So it's good to, especially at the early stage of M&A, merger and acquisition, understand these things and how they're going to apply. And then the ASX has its own listing rules. So you can look between 3.1 and 3.1B. They have an obligation for continuous disclosure. Okay, so when any entity is aware that any information concerning it, a reasonable person, so that's the man on the Platinum Omnibus in law, Southern Mid England bus. Yeah, after I take out he's a person, the average person would expect that it would have a material effect on the value of the entity's security, and therefore the entity must immediately tell the ASX